Hello, my name is Kyle Kite, and thank you for joining us for another Klaas U webinar. In this webinar, we're joined by Attorney Pat Agnew, who is a local estate planning attorney and one of our Klaas trusted partners. In this video, he will cover various topics related to estate planning. Some of these topics include what is the probate process, what are some different types of accounts to be aware of, and how a trust can help you accomplish some of your goals. We hope you find it informative and educational.
Whew, good. And that becomes even really important because if you don't have a will and husband dies, he doesn't have a will, he's survived by his wife and his two children. You don't have a will, the Illinois Probate Act says, oh, if you don't have a will, but you have a spouse and you have children, half of your estate goes to your spouse and half goes to your children. Well, that means the husband's half of the house is now owned half by his kids. So the kids own a quarter of the house. The wife owns her half plus a half of his, so she owns 3/4. And that can be a little awkward, because the wife just assumed, hey, I thought I was getting everything. And apparently that wasn't the case. So that's a little bit off the beaten path, but we've had that happen several times in the past couple years, where what you really want the deed to say or the account to say is joint tenants or joint tenants with rights of survivorship. So it's husband and wife as joint tenants, not just husband and wife. Okay. So joint tenancy will avoid probate or will get the asset to them. But, if it's own tenants in common, that's not going to necessarily go to the surviving spouse. That's going to go to the decedent's estate. So that's one way is we own things jointly with somebody. Another way is if I have an asset that designates a beneficiary. So when you set up a life insurance policy or a retirement account, they ask you at the time, hey, when you die, who do we give the money to? Oh, we'll give that to my spouse if living, otherwise to my kids or my favorite attorney or, whatever you come up with there. But that's really kind of a little will right inside the financial instrument. So the administrator, the IRA or the insurance company is just going to go right to the beneficiary that you designated, hand them the money, done deal. Again, they don't care if you have a will or a trust. It doesn't matter to them because you've already taken care of that. So traditionally, life insurance policies and IRA accounts have always been able to pass by beneficiary designation. But over the past few years, that option has greatly expanded. Most banks now have what they call payable on death. You can name a beneficiary to any type of bank account. So I can, name my child or my spouse as the payable on death beneficiary of my savings account or my checking account. And so if I have beneficiaries on my IRA and my life insurance policy and my bank accounts, and maybe my investment accounts, anything I have with Klaas, they can add a beneficiary on that. So, I can have everything go and I don't even need a will or a trust. But then we got to the house and it's like, oh, that was the deed to the house says that I own it, but it doesn't say who gets it when I die. You can't name a beneficiary to a house. Or can you? Illinois, just a few years ago, Wisconsin, even a little bit before that, Illinois has now what they call a transfer on death instrument. In Wisconsin, it's called a transfer on death deed. It's the same thing, but you can now name a beneficiary to your residence. So it's kind of like a cross between a will and a deed. It just says, we, the owner of this property, legally described as lot 3 of block 2, blah, blah, declare that when we die, we want the ownership to pass to, this beneficiary. So in today's world, it's, really possible in a lot of situations to have beneficiaries attached to all of your assets, your investment accounts, your retirement accounts, your life insurance, your bank accounts, and your house. And so that you can have all of that passed by beneficiary designation, in which case I wouldn't need a will or a trust. It would just go by the beneficiary designation. Okay. That's a tool, but it's not always a great tool. If that's what you're going to, rely on to be your estate plan, the we have two big hurdles that I've seen with that. The first one is you lose control of the contingency plan. And by contingency plan, I said, okay, well, upon my death, I want this account to pass to my 3 kids. Well, what happens if one of my 3 kids predeceases me? Oh, I don't know. What happens? Well, every financial institution has their own custodial agreement, which is basically the rules of their accounts. And in that custodial agreement, in very, very small print, about 8-point font, in page 45 in the middle of the page, it's going to say, oh, and by the way, if you've named a beneficiary to one of our accounts and that beneficiary is not living, here's where we're going to have their share pass. And at this point, it kind of goes all over the place. Some will say, well, it'll go to the children of the deceased beneficiary. Some will say, nope, it just stays among the beneficiaries who are living. Some will give it to the spouse of the deceased beneficiary. Most of them will say, you know what, we want it to go to the probate court because we don't want to get sued by anybody. So you need to go open a probate estate and we'll let the court decide it so nobody sues us. So you lose control of that. Where if you have a will or a trust and your assets are passing through there, which we'll get to in just a second, you're always going to have, because you get to write out your, it's very easy to put in a contingency plan. Oh, well, if my child is not living, I want their share to pass to their children, my grandkids. And if they don't have any grandkids, I want it to go to mother children. If they don't have any children, I want it to go to my aunt. If not my aunt, then to the charities. But you can write in contingencies to the cows come home. So you keep control of the contingency events. So that's one issue when you're relying solely on beneficiary designations. It's great if everybody dies in the perfect, correct statistical order. But if somebody mucks it up and dies out of order, it may not be so great. The bigger thing, though, is that, again, when you have a will or a trust, all of the assets kind of come into a central repository when you die. You've designated who's going to be in charge, and you've told them, hey, your first job with this money coming in from my estate is to pay my final bills and debts and expenses, because the law is very clear that that has to be done first. And then once you've paid all my debts and expenses, then distribute the rest out to the beneficiaries. Well, if we're relying all on beneficiary designations, we're kind of doing it the opposite way. All the money is flowing to the beneficiaries, it goes to my 3 kids equally. And then the funeral, home comes knocking the door and says, hey, we need 15 grand for the funeral expenses. And we're like, well, who's in charge? I don't know. I just got my check. I was a beneficiary, but I'm not in charge. You in charge? So maybe one of the kids will step, say, fine, I'll take in charge. Okay, I need 5,000 from each of you so we'll just pay off the funeral bill. But, child number 1 says, 5. Oh, you didn't see my new red truck. Yeah, I knew Dad was dying. I had that truck picked out the day that money hit my hand. I already spent. But you guys go ahead and pay that out of your share because, I'm sure the funeral home needs to get paid. Well, you can see that's going to not go very well at all. So it's a little odd to give all the money out and then try to ask for some of it back to pay expenses, which the beneficiary is thinking, well, it's not my funeral, because once that money hits their account, it looks pretty good there. They don't like giving that up. So, maybe if I just have one child, having everything passed to them by beneficiary is okay. They'll pay the bills are okay. But boy, once you get more than one beneficiary, using beneficiaries for all of your assets it usually results in some pretty big issues there. Okay. But nonetheless, that is certainly a way to pass assets to beneficiaries. So we either make them a joint owner or we designate them as a beneficiary. So those are 2 ways we can do it. I'll just kind of clean this up here a little bit. So the other way is the more traditional way is to say, well, okay, I'm going to designate, put this circle out of here. Boom. I am going to create a will. And if I don't have beneficiaries on all my assets, that's what I want my will to do. So it's going to say upon my death, I want, these assets to flow into my will. And then my will have the instructions as to where I want those assets to pass. And so that's really good. It gives a set of instructions. You take care of that. You can have those contingency events in there. Oh, and if this beneficiary is not living, here's where it goes. But it's a two-step process, okay? When you transfer an asset to a beneficiary, the first step is to identify who the beneficiary will be. This is who I want my money to go to. But the second part is the actual physical transfer of ownership, okay? So, today, my checking account, the signature card at the bank says it requires my signature on a check to transfer money out of that account. And the deed to my house, the title company knows that I, as the owner, have to sign a deed if I want to transfer that house to somebody else. So when I die and my will says, hey, I want my checking account and my house to go to Kyle, he'll be sad for a second or two when I die the next day, but then he remembers he's getting the house and the checking account. He comes to and goes into the bank and say, hey, I'd like to have Agnew's checking account balance. Here's his will. It says I get the money. And the teller looks at her signature card and says, well, sure, just have a check signed by Pat Agnew. He says, well, that's what I'm showing the will. He's not here, but his will clearly wanted me to have it. So go ahead and give me the money. Ooh, I don't know what his will says, but all I know is I can't release money without his signature. And Kyle goes to the title company and they give him the same deal. Yep, just had a Pat Agnew sign a deed conveying the house to you and you get ownership. Well, he can't, he's dead, but here's his will. Well, again, I don't care what his will says. He's the owner, we need his signature. So we're going to have somebody who at the time of the person's death has legal authority to sign on their behalf. And so most people assume, okay, well, if I'm going to have a will, one of the positions I designated there is an executor, because that's the person who I assume will step up and pay bills and write checks and be able to sign on the decedent's behalf. And that is a correct answer. But the other part that people sometimes are not as thrilled about is wills are governed by the Probate Act. And the Probate Act says, if you are going to rely on a will to hold your instructions, you may certainly tell the court who you would like to be the executor when you die, but you, as a mere mortal, cannot provide that executor with any powers or legal authority to do anything, because the Probate Act very clearly says only a probate judge can give that kind of power to somebody else. So when you name somebody as executor in a will, they're really just like Clark Kent. They have no powers. In order to officially act as executor, they have to be appointed by a probate judge. So they have no choice but to hire a law firm, open a formal probate estate, and at the first court hearing, the judge will knight that executor and give them a court order called letters of office that says, by authority of the court, you may now sign your name on the decedent's assets. And so if Kyle walks into the bank with that court order and says, I know I'm not a signatory on Pat Agnew's checking account, but this court order says I can sign on his behalf, they'll now let Kyle sign his name on my checks and can cash them out. And you can go to the title company and sign the deed to my house as executor, and it'll allow the transfer. So I think one of the biggest misconceptions a lot of people have is they feel that because I took the time to do a will, I thought I avoided the whole probate process, when in fact, the person you named as executor cannot act until they are appointed by a probate judge, and you have to open a probate estate to do that. And once you've opened the probate estate, the estate will then be administered through the court system. So this is not going to be a very fast process. It's going to take, typically year and a half, sometimes 2 years from start to finish. At the beginning of the process, the judge is going to kind of put a freeze on beneficiaries. He's going to say, hey, I want no money going out to any beneficiaries for a half a year, because I want the executor to come back and 6 months from now give a full accounting of all the assets they acquired, proof of all the bills that have been paid. If they haven't paid all the bills, come back when they have. And then I want to provide that accounting to the heirs and the beneficiaries. And if anyone objects, I'll have a court hearing. And then once everyone's signed off, then I'll let the executor start distributing out money. And the other kind of big complaint I tend to get from people, and I see we just got a question on that, is what are the costs involved. There are certainly filing fees. You're going to pay $500 to court to open the estate. You're going to pay $500,000 to the newspaper for the publishing. But the real cost is going to be what the attorneys charge. It's that law firm for the year and a half. And most states, they have statutory percentages, and those seem to run from about 4 to 8% of the asset values. Other states like Illinois say that you're supposed to be, it's done on an hourly basis. There isn't a flat fee schedule. But, I think a lot of times attorneys are kind of aware of, well, this is where, statutory fees tend to fall. So, if you're looking for an idea, that's probably a pretty good range. And, even on the simplest of a state, whether the state is $100 or $1 billion, there's a set of filings that have to be done. You have to do a petition, an oath, a bond, an inventory publication. So there's kind of a fixed cost just to open the estate, regardless of what's in it. So, $3,000, $5,000, $6,000 is probably the bare minimum you'll ever see during that, even on a pretty straightforward estate. And it can certainly go a lot higher. But it's very dependent on the law firm and where you're residing. If you're, close to Lake Michigan, the fees tend to go up. Close to Mississippi, they go down a little bit. But so as beneficiaries who've gone through the probate process, a lot of times that's their frustration. This took, a long time. I was trying to get, closure and kind of move on with my life. And we paid, this law firm what I thought was kind of a lot of money that frankly, I didn't see we got any benefit. It just seemed to be kind of a hurdle we had to overcome. So it wasn't the funnest thing I did in my life. So the other option is then say, okay, well, then I'm going to put my instructions in a trust, a revocable trust, instead of a will. It's going to do the same thing. When I die, the assets that are in the trust, this is where they will go. So it identifies the beneficiary. But trusts aren't governed by the Probate Act. So here, the trust code says, oh, well, when you attach your instructions spelling out who gets everything when you die, in those instructions, you may also indicate ahead of time all the powers that you want the person in charge of your trust to have. Well, when we do a trust, instead of calling them an executor, we just call the person in charge a trustee. It's the exact same job description of the executor. You're in charge, carry out my instructions. But here, whatever powers you give to your trustee, they just instantly assume the second you die, and they don't have to go through the probate process. So with a trust, you get to designate who you want to be in charge, and you can give them all the legal authority they'll need to act, so they never have to go through the probate process to do that. The only limitation with a trust is that these powers that you give to your trustee can only be exercised over your trust in the assets you either place in there while you're alive or that flow in there upon your death. So in other words, instead of signing your name to the trust, just like you would, sign your name to a will, we would then look at the investment accounts and say, hey, Kyle, Nate, can you please change the name on the account from my name to my trust? So it's titled in my trust. And they say, yep, we do that 100 times a day, no problem, big deal. And I go to the bank and say, hey, change the name on my savings account from my name to my trust. I could tell them to change the name on my checking account to my trust, but then they're going to make me get all new checks that say the word trust on them. They're probably going to assign a new account number. And if I have anything coming in or going out automatically, that's just like ruin my life. So I remembered that Pat said something about this payable on death beneficiary designation. So I'm going to tell the bank, hey, I'd like to name a beneficiary to my checking account, and my beneficiary is actually going to be my trust. So I'm going to leave the checking account just in my name, but when I die, it'll flow into my trust, no probate. And if I have my life insurance policy over here, instead of naming my beneficiary as my child as a beneficiary, I may name my trust, or I may elect to name them. I can, depending upon what I want to do. So the point is, I either make the trust the beneficiary or I put the asset in the trust. And once I've done either of those steps, that asset will never see the light of probate because I put it in the trust. And it isn't a hard step at all. It's just an additional step that you don't have with the will. With the will, you sign your name, you're done. We'll deal with all the assets when you die, when they go through the probate process. With a trust, you sign your name, but then we got to make sure we put the stuff in there. And for you, you don't really care about that step because it doesn't have any impact on you, because unlike a will, which only becomes legally binding when you die, this type of trust becomes effective the moment you sign it. This isn't really the legal name, but a lot of times people, you hear the phrase living trust. It's in effect, well, I'm living, hence living trust. Well, if we come to you and say, well, all right, well, this is your trust, you're alive, who do you want to be in charge of the trust? Pretty much every person is going to say, well, that'll be me. I will be in charge of my own trust. Or if we're married, my spouse and us will be the trustees together. And then when I can no longer act as trustee, then I'll set forth the people who I want to step up. But that just means initially I'm telling Kyle and Nate, hey, change the name on the account from Pat Agnew to the Pat Agnew Trust, of which Pat Agnew is trustee. And the first rule of my trust says, as long as I'm alive, there are no rules. I can do whatever I darn well please without restrictions, just like I'm doing right now. So, I could really care less if the account's in my name or in my trust name. Doesn't matter to me. My control's absolute either way. But upon my death, it's because everything that I've put in the trust here, the next trustee steps up and takes care of. But if I ended up leaving the house just in my name, they can't deal with it out here. So now I'm going to have to go to probate, get an executor appointed so they can sign the deed, which will plunk it into a will. So when people do a trust, they still do a small will that goes with it that says, hey, if I forgot something, put it in the trust for me, because that has all my instructions. But if we had to go through probate to get it there, we kind of missed the benefit. Had I simply deeded it into the trust or did a transfer on death instrument and named my trust as the beneficiary, wouldn't have had to do that. So, this isn't about being right or wrong. There's just two options to have assets flow to the beneficiaries through a legal instrument. You can either have them flow to them with a trust, with a will, but you'll have to go through probate to empower the executor to act, or they can flow to them through a trust, in which case you won't have to go through probate, but then you got to make sure the assets, flow through the trust, either at death or by beneficiary. And when you do the trust and set it up correctly, it is really easy for the next trustee in line because they can just step up right away. They don't have any 6-month requirement. There's no minimum notice period. They can just step up, carry out your instructions, and handle things pretty easily. So to me, those are the 4 ways money can pass: joint owner, beneficiary, a will, or a trust. So everything has to go at least one of those routes. And it can be, a combination. I might have a trust and I've got my checking and savings account in there, but I've got my retirement account going, directly to the beneficiary, not through the trust. Or, and I've got some unique instructions in my trust. And so I want my IRA to flow into my trust when I die, so I can put some unique instructions. It just depends what your instructions are, where things would pass. So I saw one of the questions earlier. The first one is, I think it was, if my house passes to my children upon death, is there a step up in cost basis? And when you, I buy my house for, $50, and then over time it appreciates. And now when I die, it's worth $75. Well, if I was still alive, I should back up. If I sell an asset that I bought for $50 and I sell it for $75, that $25 is my capital gain. And so ordinarily you'd have to pay income tax on that capital gain. A house is probably a bad example because there actually is an exception for your personal residence. But nonetheless, so this is what they call your cost basis, what you originally bought the asset for. And when you sell it, they compare to the fair market value. So when you die and a beneficiary receives an asset at death, the cost basis to the beneficiary gets stepped up to the fair market value. So if I'm a beneficiary, my mom dies, I receive the house, and it's worth $75 at the date of her death, that becomes my cost basis. So if I sell it the next day for $75, I've got zero capital gain. Okay. And I think the other part of that question was, well, if I have a trust, does that avoid the capital gain? And the answer, it's irrelevant. It's the same. So if my house is in the trust, I bought it for $50, and now I die and the house is still in the trust, but it's worth $75. Whoever the beneficiaries of my trust are will inherit the house with a cost basis of $75. So you get the same step up, whether it's in trust or out of trust. So a revocable trust is really a tax neutral instrument. Now, the revocable trust would allow the house to pass to me without going through probate. That would be the benefit. So, the one benefit of receiving assets when somebody dies is basically all the appreciation disappears and the beneficiary receives the asset with a cost basis at the fair market value at date of death. So, sometimes that can be pretty substantial. All right, too much excitement? Are we still okay? Anybody asleep there, Kyle? Or we
I think we're still good. I think you didn't
need
get
oxygen?
those questions. So,
So one of the other things is when we look at your basic instructions. So I've got a will or I've got a trust, and it's like, okay, I want to have some instructions. So, one of the things you have to do is put yourself in the correct mindset. Okay. And when you put a will or trust in place, what you really need to tell yourself is, this is my emergency plan. That's all I'm doing today. If I were to die tomorrow, which would be the emergency, this is what I want done with all the assets I've accumulated during my life. And it's based on the world as it exists right now and today. If I don't die today, I can change the instructions I come up with next year and 5 years and 10 years from now. So we don't really look at, well, if I live 20 years or 15 years or 30 years, it's just pretty much if I die tomorrow, this is my emergency set of instructions. And if I hang around for a while, I can always change them going forward. So part of the process is you got to realize, well, if you did die tomorrow, for the most part, we're going to liquidate your assets. So if you have any life insurance policies, we're actually going to write the insurance company and cash those in. And if nobody's going to live in your house, we're going to sell that and turn that into cash. And we're gather your retirement accounts and your bank accounts. And so for a lot of people, there's more cash available when you're not here than when you are, because you don't get any benefit of the life insurance while you're alive. But when you die, bing, it pays off. And your house isn't cash today because you're living in it. So for most people, that pot of gold is a little bit bigger if you're not here. But that's an important thing to realize, because, sometimes it's pretty flippant to say, yeah, I'm just going to give this, to my 2 kids. Okay, if your estate's $100,000 and they're each getting $50,000, that seems pretty good. What if your estate's $1 million and they're getting $500,000 each? Oh, 500. Oh, that's a little bit different. So the 3 questions that you really have to ask yourself in your estate plan is, okay, if I die tomorrow, who would my beneficiaries be? How much would each beneficiary receive? And then when would they receive that share? And I think this is the question that gets most overlooked, okay? Because typical parents, I've got 2 children. I'm going to name my 2 children as the beneficiary. So that's the who. The how much, you really don't want them to keep fighting about who the favorite was. So settle that for them and give the favorite 51% and the least favorite 49%. And then they won't fight about it anymore. But give that advice a lot. Nobody ever takes up. They all go equally. So that's fine. But we get down to the when, that's where you've got 2 choices. Once I've identified a beneficiary and the amount they're going to receive, if they're at least 18 years of age, option A can be, I would like them to receive their share outright. See, the beneficiary's back here again, arms are up in the air. Or option B is you could say, well, I want to leave instructions and I would like their share of the estate to go into this trust for their benefit. And I think ordinarily parents only consider this option when this person is a wee young person. I've got a 10-year-old child. My estate's $500,000. I can't leave $500,000 to a 10-year-old child for a whole list of reasons. So I want that money to go into a trust for their benefit until I feel they're old enough to handle that kind of money. And that might not be till they're 25 or 30 or maybe even 35, whatever numbers you come up with. But prior to that time, they can use the money in here, but it would be for kind of basic necessities. So if they need money for their everyday living needs in my absence, their food and clothing and their shelter, I would probably make sure that their medical and healthcare needs are provided for. And if they're young, I'd probably even provide for their education. So again, in my absence, feed them, clothe them, provide for the medical care, educate them. But otherwise, they got to wait till they're 25 or 30 before they get this sum of money. So that is certainly one reason why parents would create a trust. And generally that is only when I don't yet trust the beneficiary to handle the sum of money they would receive. So I need it held till they're old enough. But then we've got a lot of parents today whose kids are in their 30s and even 40s. I trust my child implicitly to handle the sum of money I'm going to give them. What I don't trust, however, is their spouse just out of the blue, 6 months after I die saying, "Ooh, I'm no longer happy. I think I'd like a divorce. Ooh, and that $500,000 you just inherited, I'll be taking half of that with me as I leave." Or I got in a car accident, or I hit a school bus, or somebody slipped on my deck at the party last night, or I had some illness and incurred all kinds of medical bills. Well, legally, there's a big difference here. Once money has passed to a beneficiary, even if they're the most prudent beneficiary in the world, if they get a divorce or a car accident lawsuit, well, it's in their name and it's available for the taking. On the other hand, when the money is still sitting in this trust, even though this child is the only beneficiary of the trust, while the money's in here, they do not yet own it. It's still owned in your trust. And if they don't own the money, it can't be subject to any judgment. So that is a 100% creditor-free environment. So no matter what happens to them legally, nobody can come and take that money because it's not theirs. They don't own it yet. So I think some parents look at this as kind of like a safe. I'm going to give my child the combination of that safe. I'll allow them to pull money out, but nobody else can touch that. So now if there's a divorce, well, you can divorce me, but you ain't getting any of the money. And if there's an accident, whatever. Well, if parents set this up for asset protection, it tends to then be held in trust for a longer period of time, because this isn't when I trust them to handle money. I mean, if they're old enough, that could be right today. No, this is how long I want to guarantee them nobody can take this money from them. Well, and one of the things, if you're going to open this up for for an adult beneficiary, I'm going to hold this in trust for a longer period of time, we're typically going to open up the access quite a bit. So one of the first things we typically see is a person that says, well, right off the bat, or once they're a threshold age, once they're at least 21 or 25, I'd like them to start getting a check from this. But I'd like the check to be on a monthly basis and not something that's really overwhelming, but something that's a lot more manageable. So, you would typically pick a percentage, 2, 3, 4%. And for easy math, I'm going to say, let's say this child's trust had $800,000 in it. So if I'm gone, then we'd say, okay, well, January 1st of each year, multiply the balance of this trust by 3%. So initially that would be $24,000. Say, okay, that's what I want paid out this year, but I would like that paid monthly. So divide that by 12. They're going to get a $2,000 check first day of each month, like clockwork. And when that check hits their account, there's no restriction on it. Do whatever they want. It's automatically deposited into their account. They don't have to ask for it. And if they, blow the first 4 or 5 checks on whatever, well, it's kind of okay, because that was just the cream off the top. It didn't touch the principal here. But it's interesting, watching beneficiaries for 40 years or so. I don't care who they are. By the 5th or 6th month, it's, hey, this is really weird. This $2,000 check shows up the same time that my mortgage payments due and my car payments due, and hey, I could use this to pay my monthly expenses. And man, would that take a little bit of the edge off me? And it's a very digestible amount. It doesn't blow me away. And the neat thing is that the money in the trust will continue to be invested. Well, all Kyle and Nate have to do in this example is do better on average than 3% a year. Well, if they got a 7% that first year, even though we paid 3% out, the trust grew by 4%. So January 1st, year 2 after your death, it's 3% by a bigger pot, which means the monthly checks go up a little bit that next year. And the trust grows again. So the year after that, the checks go up. So each and every year, there should be a nice little increase. So it's kind of like a monthly pension. And each January, we're going to recalculate that so it keeps up with inflation. And, typically you give that 10 or 12 years after death, that pot should have doubled. And now I'm getting $4,000 or $5,000 a month. So it's a very powerful little tool. And then in addition to that, you'd say, now, if you need more than that monthly check, I want you to have access to the principal as well. But if I'm going to have this go into your adult years, we might add some more adult kind of needs. If you need money for the down payment for a house or a vacation property, or if I'm not here and you get married, I want X amount of dollars available for your first wedding. And then after you're married and you have your children, my grandchildren, if you need help with their education, I'd be all about that. If you get the ability to buy into or start a business, or I want you to buy a car every 2 years, or I want you to travel, take the family on trips, or anything that you feel is in your best interest, which is the absolute broadest term we have. So you decide, how wide or narrow that door swings above and beyond that monthly check. And that's what we have to sometimes, oh, wait, I forgot they're getting 24 grand a year. Yeah, you can buy your own car out of that. You can do your own vacation out of that. But yeah, if you're sending your kids to school or buying a house, I want that money there for you. So if you kind of identify the things that adults would typically need money for and give them the ability to pull that out, and in addition to that, they're getting a monthly check that you don't have to ask for, and the golden goose who's providing all of this cannot be taken away from them under any circumstance, it really isn't a bad deal. I mean, that's a pretty nice setup for beneficiaries. I don't have the stress of worrying about, this being, taken away from me. I don't have to worry about getting a huge lump sum check that can be pretty overwhelming. So it's just a tool to be aware of. I think most people only think the first type of trust, where it's just for a small child and it's very restrictive. That's kind of what they think about. But, you can set up a trust for an adult child that gives them all kinds of flexibility, but at the same time, providing some asset protection. And when you get down to it, again, this is the core of why you're doing your estate planning. These are my basic instructions. If I die tomorrow, this is what I want to have happen. And you certainly don't have to have it go in trust. I mean, you can absolutely say, yep, I want my kids to get it outright, but at least I made that decision knowing what my other options were. Or, and I like that trust thing. I like the protection. I might want to set something like that up for my kids. So that's a really key part. And then once you've come up with those instructions, you either say, okay, I'm either going to place them in a will, or I'm going to place them in a trust, and they'll be carried out upon my death. Ba-bing, ba-bing. Good? Everybody still awake, Kyle? Does anybody need any oxygen? Is this too?
I think they're doing good. We got a couple questions though, Pat. Is naming a beneficiary for your house as fast or as good as putting the house in a revocable trust?
So is naming the beneficiary, it really is, it's really the same, because if you do a transfer on death instrument, or a Wisconsin transfer on death deed, the law provides, it was amended. It used to have to file a death certificate. It says, hey, this person died, I'm the beneficiary, so now I'm officially the owner. Illinois modified that to say, well, you don't have to file that. You kind of become automatically the owner. If it's in a trust, as soon as the death certificate's there, the trustee can sign a deed. So it's really, it's the same. I will say this though, there's one good point there. when you have a trust and we have the house either in the trust or we do the transfer on death instrument that names the trust as a beneficiary. So it's going to flow in there either event. When the house leaves the trust, especially like if it's going to be sold, there is no additional cost on the title insurance. But if I have a beneficiary and I name them individually as the beneficiary under transfer on death deed, that means it didn't go through a will, it didn't go through a trust, there was no legal process. So a lot of title companies, when you go to sell the house, will charge a premium on the title policy that I think, depending upon the title company, is going to be about 2 to 4% of the purchase price as an additional premium, because they don't have the, when you have the certainty of going through probate or a trust, they know ownership and it's all settled and claims. When it goes directly to a beneficiary, they don't have that comfort level that there might be a claim or some lawsuit, so they charge a little extra for that. So the speed would be the same, but it's going to be probably less cost if it goes through a trust. Whew, little known fact there. What else you got?
Oh, whoops. Does an attorney have to set up a trust, not finance guys? Correct. Yes, you do not want myself or Nate writing your trust. You should always have an attorney draw up a trust.
And by the same token, don't have me do your investments. So it goes both ways. Oh, the inherit IRA and 401k in the 10 years, right?
Yep, I think they jumped ahead of you, Pat, where you were going next, probably.
Let's see, where's my, which picture I have here? Down here. So we have this new act, the Secure Act, which is an acronym for that, setting every community up. So when you have a retirement account, 401k, IRA, 403b, when you're working, you don't pay any tax when you put the money in the account. And while you're working, it gets to grow. You don't pay any taxes on it. But the deal is when you retire and you pull the money out, then you have to claim that as income and pay the taxes on it, right? Well, when you die, that income tax does not go away. The IRS is very much aware they never got their claws into that money. But the nice thing is the IRS, fortunately, is very flexible and they're willing to tax anybody, including your beneficiaries. So when you die and your beneficiaries inherit that account, they will also have to claim that as income as they pull it out, just as you did. Now, prior to 2020, the deal used to be the IRS would say, oh, well, if mom or dad die and now the 3 children inherit the retirement account, here's the deal. We're going to make them start taking minimum distributions the year mom and dad die, even if they're not retirement age. But we'll let them spread those distributions out over their life expectancy under the IRS tables, which the old tables put life expectancy as somewhere around 83 years of age. So if I was a 30-year-old child and I inherited an IRA account, I would have 53 years, 83 minus 30, to take these distributions. So I'd have to take 153rd of the account the first year, and then 152nd the next year, and 151st year after that, and I'd only pay tax on that little bit each year. So, if you were kind of a younger child, you could really stretch that out over a long time and really get some benefit by deferring all that tax. So in 2020, the IRS must have finally figured this out, because they said, you know what, it's taken us a really long time to get all our taxes from these accounts. First of all, mom and dad both have to die, and then their kids have to get into their 80s before we ever get our taxes. So we think that's too long. So we have a new deal. Anyone who dies after January 1st, 2020, and they inherit an account, we would like all our taxes paid to us within 10 years. We don't care the speed within which you pay those taxes. You could pay it all the first year. You could wait till the 10th year, do a 10th each year, We don't care. Just by year number 10 after the IRA or account owner's death, we would like all our taxes paid. And that was a significant, huge deal. I mean, if this was $1 million IRA and I'm the only child, that means I'm going to have to add $1 million to my taxable income over the next 10 years. If I spread it over 10 years, that's $100,000 a year. That's going to put me up some tax brackets. So it's a tough rule, okay? But one of the things that you can do, I think, I don't think people quite realize this, is if you set up a trust for the child and they inherit, they inherit some of the regular assets, the house and the bank accounts and the tax-free assets, and they also inherit, part of your IRA or 401k account. Typically, when we set up the trust, Kyle and Nate would set up 2 accounts. They'd say, okay, we'll set up an account that under the trust that holds the IRA, and then we'll set up an account under the trust that holds the non-IRA assets. So you kind of have 2 accounts. And we've got the beneficiary down here. And maybe, the trust has one of those 3% unit trust things that says, hey, I want you to pay out 3% a year. So, for the first 10 years, the child could say, well, I could pull those distributions out of the tax-free money and not have to pay any tax on that. But then the IRA account's just going to grow if I'm not taking any money out of there. And when I get to year 10, it's going to be really big. And they're just going to go, boom, you got to declare all of that as income and give us our taxes. So although it seems a little counterintuitive, the beneficiary is probably better off saying, you know what, during those first 10 years, I'll take my monthly checks out of the IRA account, and I will have to pay income tax as I pull them out. But, as a beneficiary, I might be at a 22% or a 24% tax bracket. If I wait till year 10 and let the IRA get really big, and now I got to pull out, $700,000 or $800,000, then I'm probably at the 37, the top bracket. So anytime I can pull money out at less than 37, that's better. Well, that's great. Each year the child can, those first 10 years start pulling money out of the IRA account to get that tax at their lower rate. But when you have a trust for the child, you've actually given them a second beneficiary that they can also pull money out of. So, and in general, we don't like trusts to pay income taxes because their rates go up pretty quickly, which is true. When we look at trust income tax brackets, after a trust earns $13,000 of income, it's up at the 37% bracket. A person has to earn about $500,000 or a couple $600,000 to get there. But these first brackets actually aren't too bad. The first $2,700, a trust only pays 10% tax on. And the next $7,000, they pay 24%, but they're still paying 10% on the first 27. So the blended rate is only about 21%. And even that $13,000, that last $4,000 is taxed at 35. But again, because these first rates, the blended rate is only about 25%. So we could come over here and say, hey, what if the trust pulled out, an additional $2,700 each year during 10 years? It would pay 10% tax, so it'd pay $275, and the rest of the $2,500 would come over here. So each year we're also pulling some money out, letting the trust pay a smaller tax. Or even if I pulled out $9,800, it's still only paying, again, about a 21% tax. So we can start putting more money over here, and the child's taking some money out as well. So by the time we get to year 10, between the trust and the child, hopefully we've been able to pull all or a good chunk of that out at something way less than 37%. So a trust can actually be very helpful with the Secure Act because you've given your beneficiary a second taxpayer to help get those dollars out at something less than what was, the big tax if we did it 37%.
And Pat, that would work only if you name the trust as the beneficiary of the IRA, correct?
Exactly. Yeah, I have to name my trust as a beneficiary, not the child. exactly, Nate. But I think you hear a lot of people, oh, don't name a trust, don't have a trust. I think that's incorrect. If you know what you're doing, a trust can actually help the kids out quite a bit.
Pat, is there an exception for the surviving spouse as well for the 10-year rule? If one spouse passes away and names the other, the spouse does not have to commit to the 10-year commitment?
Yeah, there's a couple of rules. If I have minor children, which if they're under 18 years of age, if I have a disabled child or my spouse, the Secure Act 10-year doesn't apply to them. So if I name my spouse as a beneficiary, they still get to take under the old rules over their life expectancy. And if I have any minor children under 18, they qualify. They're exempt from that as well. Yeah, that's a good point. What else we got, Kyle?
Those are the big ones that have come up. I've just been answering a couple simpler ones that we've done. So good. Anything else you want to cover, Pat, or you want me to open it up for live questions?
Do it. Live, easy. Go for it's the easy part.
Okay. All right. So I am going to turn everyone's mutes off, or I'll allow everyone to talk, but if you want to stay muted, you can, but we'll open it up for some live questions. Someone had their hand raised. Who is that?
Yeah, this is Rich Brown.
Hi, Rich. How are you?
Good.
Good.
A question for Pat. In setting this up, initial consultation, do you do that free of charge to discuss what you might recommend, and do you come to, I'm in Milwaukee.
Yeah, I mean, we do a lot of, because we're licensed in Wisconsin and Illinois, and so a lot of times we'll do that by Zoom.
Okay.
Ordinarily, when we have clients come in, we'll charge $200 for the initial meeting, but if they go forward, that counts as part of the price. But if you're referred from Klaas, just tell us that and we waive that.
Okay. So then, would that be wise to put a list of things together that we have, forward that to you, and then we can do a Zoom meeting or something of that sort?
Well, what we would normally do is we would just send you a packet ahead of time. We just have two little information sheets. One is just give us your name and the name of your kids or family. And the other is very, very simple asset thing. Just, I don't care about account numbers and balances. And actually, if you have stuff with Klaas, they'll send it. But just so I get kind of an idea, are there retirement accounts, life insurance? So we'll send you that ahead of time. And so when we meet, I've already kind of got a good idea of what's there. Yeah, and then we'll go through, here's maybe the 2 or 3 or 4 different ways you could approach this. Here would be the cost of each one. Here's the savings of each one. And you can pick one I want to do or none of them. I mean, so there's no obligation to do anything. And at least our firm, we always operate on a flat fee basis. So we'll give you a flat fee for the project. No surprises, no clock running.
Okay, so you do the will and setting up the trust, if that was decided what to do, the whole works?
Yeah, when we get to the end of it, then we'd work with, Kyle and Nate or advisors to say, okay, now we got to make sure we get the beneficiary set up the right way or the accounts titled the right way. But yeah, that would be getting all the documents, the will, the trust. We didn't talk about powers of attorney for property and healthcare. Those are all part of that.
Okay, then once we have the spouse, myself and my spouse, then once we were gone, and there's the executor, do you assist that executor in completing all the tasks that are necessary?
Absolutely. They're not compelled to call us, but it's pretty common that they tend to call the firm who drafted the documents. Yeah, we do that on a daily basis. We've got that down. We've got good checklists for them, and we'll lead them right through that process.
Okay. Then do we have your contact information if we decide to go forward with this?
We can get it to you, Rich. We've got all Pat Agnew's info for you. Yep.
Okay. And I would appreciate that. We'll kind of talk about it. It's something we've got a will now. We just need to update.
It's a lot of fun. So, it's an out.
Yeah.
Well, for me, it isn't so bad because I was a former banker, but yeah, for the average person, no, they're not going to like it.
Oh, you're killing me, Rich. Come on.
I was the compliance officer, so I know what that is. So.
Yeah.
Okay, yeah, if I could get that information forwarded, that would be good.
Yep, we'll get it sent over to you, Rich. Not a problem. Thanks for the question.
Okay. You bet.
Another question we had come through in the chat, an example of a non-IRA. So a non-IRA, as silly as it sounds, is anything that's not an IRA account, but some common examples would be like an after-tax investment account, anything that's in a checking account or a savings account, anything that's what they call not qualified under ERISA would be non-IRA accounts. But thanks, we've got some good questions. Okay.
Oh, Rebecca's question, if an IRA grows before the 10-year tax due, is the IRS allowed to take the additional growth of the IRA above what the original IRA had when it was up on inheritance? Yes.
Mhm.
So again, whatever the balance is, as the money is pulled out, you have to claim that as taxable income. If you wait until the last year, or if there's any money left by year 10, you will have to pull that out, claim that as income, and pay the tax on it.
Mm-hmm. You keep the money, Rebecca. You keep the money, but they force out an income to you.
It's kind of like a big Roth conversion, right? It's a forced Roth conversion.
Are stocks handled any differently? There's a few different ways to answer this question. So individual stocks get a step up in basis on death, just like a home does or a mutual fund does, anything like that. But typically you would own stocks inside like a brokerage account, an after-tax investment account, or an IRA. So if they're held within an IRA, it's the same tax treatment as anything else you would own inside an IRA, and then it's all income taxable. If it's owned in a brokerage account, that's the most common after-tax account, they get that step up in basis. And then so when they sell it, they would have to pay gains on anything above what the date of death value was.
So, the general rule is whenever you're a beneficiary, when you inherit money, you don't have to pay tax on it. You don't have to claim it as income. The big exception to that rule is if it's a retirement account like an IRA or 401k that has that deferred tax built in. But other than that, generally everything you get as a beneficiary is tax-free.
Mm-hmm.
It's a good deal. If you can sign up to be a beneficiary, do it.
Yeah. Good. Anyone else have any other live questions?
Yeah, this is Shannon. I have one more question.
No problem.
I have lots of questions. So you were saying, so you can, under that Secure Act, you can take money out, but you can also transfer money to a non-IRA?
So again, if the trust is the beneficiary, the IRA, when you pull money out of the IRA, what happened there? It has to come through the trust, and you either pay that directly out to the beneficiary, or the trust can say, I'm going to keep it in the trust here, and the trust will claim that as taxable income, and it'll pay the tax on it. But then after it's paid the tax, the remaining dollars get to stay, in the trust. So okay. You have to have the trust as the beneficiary. And if that's the case, then you get to determine whether I would like it to be paid, directly to the beneficiary or to the trust, or both.
Okay. Thank you.
Yeah.
But you'd have to make sure you have, language in the trust that says, hey, when IRA money comes in here, the beneficiary can decide if they would like the trust to keep some of it, or if they want to pay it out to the beneficiary. You'd have to have language that gives them the ability to do that.
And Pat, some of that recommendation, a lot of it would depend on the tax bracket of the beneficiary, correct? That you're saying it may be lower for the tax at certain levels, depending
Right.
where the individual beneficiary is at.
Yeah, and that's why it's important for the language and the trust to be very flexible. You can't tell them you must do this or can't do that, because I don't know what the beneficiary's tax rates will be or the law. So you just say, I'm going to give the beneficiary the ultimate flexibility to use the trust in whatever way they can to help them get taxes out as low as possible.
Yeah.
You ready for the test on that one?
No.
All right. Well, good. Anybody else? Well, we still got Pat here. Like I said, ask a live question or the chat and question and answer box. We're watching both of those as well.
Pat, one common one we have come up at the office is maybe in a second marriage where they have children from a previous marriage and kind of a blended family, and how to name beneficiaries on that, where we see, they name the new spouse as beneficiary, but then that person could potentially name their own beneficiaries if they inherit that asset, and just, disinherit the prior marriage children. If there's any strategies or advice for someone in a second marriage to be aware of.
Well, I think there is. And before the Secure Act, we really didn't do it very often. But now you could say, okay, if I have a second marriage, you're right. If I have my spouse over here and I name my spouse as the direct beneficiary of my retirement account, when I die, they become the owner of that account, and then they can change the beneficiary to their kids at the exclusion of mine. And when they die, my kids never get anything. So I'm not thrilled with that. But I also want to provide for my new spouse. So one of the things we can do now is say, okay, well, I'm going to name my trust as the beneficiary of the IRA. And in my trust, I'm going to say, if I'm survived by my spouse, any retirement accounts coming into my trust, the required distribution must be paid to my spouse. And because they're an exception to the Secure Act, by putting in wording that says required minimum distributions must be paid to them, that will allow us to use their life expectancy just the same as if I gave it to them outright. And so they'll get the same benefit coming out of my trust that they would have here. But then upon their death, if they have not yet consumed the balance of the IRA, now I can say I want the remaining balance of the IRA to pass to my kids, or our kids, but I still get control over where that does. And before the Secure Act, we would rarely do that, because by having it paid to the spouse first, it would have eliminated the ability for the kids to stretch it out. And that was such a huge tax benefit. We didn't want to do that. Well, now, after the spouse dies, everybody has a 10-year life expectancy. So this is a great tool that we didn't have before for a second marriage. So now my spouse gets all the required distributions that they would have normally. But again, upon their death, if they don't consume it all, I can still assure that the remaining balance goes where I want and not to my spouse's kids or their new spouse. So that's a really good point. That's a great tool we didn't have before.
Mm-hmm.
So there's a couple of good things from the Secure Act, not a lot, but that would be one of them.
Good. Well, we haven't had any other questions come through, so we must have hit most of them. So we
put them to sleep.
That's right.
Yeah.
So thank you everybody for joining us. This webinar has been mostly recorded. I missed the first couple minutes of it, but we got it mostly recorded. So eventually it will go back up on our website. So if you guys want to review this at any future time, you can do that. It's under our resources tab on our website. And then if any of you would like Pat's contact info, just shoot us an email here at Klaas Financial. You can either use our info at Klaas Financial as a general mailbox, and we can get that to you. Or if you work with one of our advisors, just email your advisor, and we'll be happy to get Pat's info over to you. So Pat, any parting thoughts?
Safety first out there. Don't use this stuff. You got to have it in place, but don't use it.
That's right. It's a good point. All right, everybody. Well, thank you for joining us, and thanks for trusting Klaas Financial, and we will do these again sometime. Thanks, guys.